I'm happy that the numbers are consistent, and I will be happy if this consistency continues, because if the consistency continues, we will also be pushed to work harder, get good topics, and the master speakers of the topics also. Today, our speaker is one of the founder member of this series, who has now been elevated. Maybe he is sitting 4 or 5 feet higher than us, but today is with us to speak on the subject of law of wills. I would invite one of his disciples, Gayatri, to invite the speaker of the day.
Very good evening to one and all present here. I have a very tough task of introducing a person who requires no introduction at all. Needless to state, we all have heard about the speaker's achievements in his 27 years of practice as a lawyer, and on 7th of February 2023, we saw the speaker was sworn in as the additional judge of the Madras High Court. Accolades beckon the deserving is so true for the speaker here. Rewinding 2 months back, I was a happy, carefree junior with 7 years of practice in being called Mr. P.B.'s junior. I was the witness to the fact that his reputation was more valuable than money. A person of few words and very unassuming, whether be it up there or whether arguing among one of us. I watched the speaker work on his 4 books, and one of which is today's topic, the law of wills. I've had the opportunity to work alongside the speaker as well. I would say he's worked tirelessly, enjoyed it thoroughly, never once complained of it. He made it look so simple to author 4 books in a row and called it Lockdown Babies. Today, all 4 books are sought after. I'm happy today for 2 things. One, I'm here to attend a speech, which is a subject very fun. And second is that I'm listening to a person who's very favorite speaker for all of us here. In one line, if I have to describe the speaker, he's a good judge, not a good judge who is not impartial, but one who has prejudice for good. With no further ado, I take pride and privilege to introduce my then senior Mr. P.B.Balaji and now his lordship Sri Pillai Pakam Bahukkurvi Balaji.
Thank you, Gayatri. Very good evening. It is always heartening to see a crowd like this on a Friday evening. So as Srinath said, depends on the speaker also. So it will probably not let you down today. This is a maths class, probably 4th standard or 5th standard. Teacher was teaching percentages. This teacher posed a question to the students, and she framed a question. She said, a very wealthy man who owned about 5 bungalows and was worth 50 crores of rupees wrote a will. He gave 1/5 to his wife, 1/6 to his 2 sons, 1/8 to his daughter, and remaining to his household helpers like servants and drivers. So she asked, what does each get? You remember, she was teaching percentages. But this very young boy, very naughty, mischievous boy said, what does each get? Each one gets a lawyer. So where there is a will, there is a lawyer. And after about a month, I can assure you, where there is a will, there is also a judge. Especially sitting in first appeals and OS appeals. I am seeing at least 3-4 cases of wills before the bench. And we definitely look at it from a different perspective altogether. So where there's a will, there's a way is gone. Where there's a will, there's a lawyer is gone. Where there's a will, now there's a judge also. So that's why probably I'm invited. Wills is always a very interesting subject because it is a very solemn document. The person who writes the will is not alive to speak about it. That is the most charming aspect about a will. To give you a brief history of how the system of wills developed in this country, in 1865 we had the Indian Succession Act. In 1870 we had the Hindu Wills Act. So before 1925, oral wills were permitted. Even before the Indian Succession Act came into force, oral wills were permitted in India. But for Hindus, the Hindu Wills Act of 1870 said will has to be in writing. So one part of wills were made compulsory to be in writing, could not be oral, that applied to Hindus. But with the coming into force of the Indian Succession Act 1925, on 30th September 1925, the position saw a sea change. Except Muslims, a set of different rules were framed for Hindus, Christians, Parsis, Buddhists, Jains, Sikhs. We are now governed by the Indian Succession Act of 1925. Not very many amendments to the Act since 1925, but a very major amendment in 2002, by Act 26 of 2002. Christians are exempted from probating or seeking for letters of administration of a will. Previously, 213, if you know section 213, the requirement of probate or letters of administration, in order to make a will admissible as evidence in a court, you had to either probate it or grant or obtain a grant of letters of administration. I will tell you the difference between the two subsequently. This amendment said Christians also are now exempted. So, along with Muslims, Christians now are also exempted from seeking probate or letters of administration before marking the will as a document in a competent civil court. What is a will? I think most of you know it. Will it comes from a Latin word called voluntas. It means a declaration of a person as to how his estate should be taken after his lifetime. So this is the basic concept of a will. It is different from a settlement deed or a transfer or a gift of, it is not a devolution, it is not a transfer of property inter vivos. Like a sale deed or release deed, it is between two living persons. That is called a transfer inter vivos. But a will is not a transfer inter vivos, it is a transfer by devolution. And we are governed by the Indian Succession Act. There are different kinds of wills. Basically, if you categorize, two broad categories are privileged wills and unprivileged wills. Privileged wills are available only to army, persons in the army, navy, and actually engaged in warfare. But they have some special privileges. That is why it's called privileged wills. For the common man, we have unprivileged wills. So we are bound by I'm going to give you a very brief introduction about privileged wills and come back to unprivileged wills, because day in day out we are concerned only with unprivileged wills. Privileged wills are wills which can be entirely in the handwriting of the person, not signed. It is still his will. He need not sign his will. Suppose he dictates it to somebody, he only has to sign. There need not be two witnesses. I think all of you must be knowing it is mandatory for a will that there must be two attesting witnesses, minimum two attesting witnesses. But for privileged wills, there need not be any witnesses. If the document is written by somebody or document is written by the testator himself, the requirement of attestation is dispensed with. Suppose he makes it an oral will, that also is permissible. It is valid for 30 days. Suppose a soldier is going to die, he's been shot by a bullet, he knows he's going to die. He calls his friend, other brother army man, he says, this is how my property should go. That will is respected. But there is no time for him to go search for a paper, pen and write. So that will is valid. Provided he survives, he does not survive for 1 month. Suppose he survives for 30 days, then that will automatically lapses. So the purpose of the privileged will was to take care of the situation of emergency. Once the 30-day period is over, the oral will is no longer permissible. Suppose the person after the war chooses to execute an unprivileged will, the privileged will will automatically get revoked. Now, this is briefly, I think this much is necessary for practicing lawyers insofar as privileged wills. Okay, I don't think any war is going to happen in the near future. Coming to unprivileged wills, there are several categories of wills. First is an oral will. As I told you, it is not applicable any longer after the commencement of the 1925 Act. Then a holograph will. Holograph will is a will entirely in the handwriting of the maker. When the testator himself writes the will, it is called a holograph will. it has a very special status when it comes to proof of wills. Because courts tend to give a lot of credence to such wills, because it is in the handwriting of the maker. The pen follows the mind. So that is the logic behind a holograph will. The pen follows the mind. So I am not giving it to somebody, somebody gives me a draft, I don't read it properly, there are mistakes. It is not this case. I am writing my will. So that means more credence can be given to such a will, holograph will. We still find a lot of holograph wills. Of course, the requirement of 2 witnesses is not dispensed with for a holograph will. There has to be 2 witnesses. And what we have is called a joint will. Probably a husband and wife own properties. Husband may own property X, wife may own property Y. Both these properties, they come together and write a joint will. In respect of 2 different identity persons of different identity, properties are different, but they still come together and write a joint will. This is called joint will. Then there are mutual wills or reciprocal wills. Mutual wills are where 2 persons, it is not a joint will. Mutual will need not be a joint will. Mutual will is where X writes to Y, Y writes to X. It invariably, in the case of husband and wife, you will see joint mutual wills. And I am giving it to you, you give it to me. So it's reciprocal. So it's called mutual or reciprocal will. Then we have contingent wills. It depends on a condition. Suppose I am going abroad. Something happens to me during the flight, I am afraid. I don't want my property to go as per the succession laws. So I write a will saying, I am embarking on a journey abroad. So if anything happens to me, this will come into effect. The moment I come back to India, that condition is no longer existing. Therefore, it ceases to be a will anymore. This is called a contingent will. Then we have the very important concept of living wills. This concept is not, in fact, very new concept in India, I would say. We have all heard of the word euthanasia, a right to die. Giving a person a right to die, it is recognized in foreign countries, but it is, in fact, I would say, defies the logic, the very definition of a will, because a will is a document which comes into effect only after the lifetime of the person who writes it. But we call it a living will. The new concept which is now developing, in fact, recently the Supreme Court in 2018 common causes case, they set out guidelines. They respected a person's wish. Suppose a person is undergoing treatment for say 3 years, 5 years, and doctors have given up hope. An option is given to the person to make a judicious, conscious decision to end his life. Whether he should be medically terminated or whether he can be avoided giving medicines or treatment. So this concept for the first time in common causes cases before the Supreme Court, they set out a number of guidelines. Virtually it is impossible to write a living will if you want to go by the guidelines which the Supreme Court has laid down. As late as January last month, 24th of January 2023, it was revisited. The common causes case by way of a miscellaneous petition was revisited, and some of the guidelines have been watered down. The power given to the judicial first-class magistrate was enormous under the earlier guidelines laid down by the Supreme Court. Now it has been watered down, and even if the notary public, a declaration is made before a notary public or a gazetted officer, it is sufficient. But it goes through a 2-3 tier test, the primary medical report, secondary medical board. Once you pass all these tests and both the boards certify that what this man says is correct, he cannot be treated, any treatment given to him is not going to be successful, you can allow him to die as per his wish. If both the boards, primary medical board as well as the secondary medical board, give that certificate, then the procedure can be followed. What happens if primary medical board says you can terminate, secondary medical board says no, we disagree, then the power is given to the High Court. The Chief Justice will appoint a division bench specifically for this purpose to go into the veracity of the two reports or the conflicting reports and give a final comment. If the High Court agrees, yes, this man knows what he is doing, he knows that he is not going to survive, the decision he has taken is right, if depending on the medical advice the High Court gets. High Court also can get an independent opinion from 3 doctors. A team of 3 doctors with an experience of not less than 20 years. So High Court can form a committee of 3 doctors, get their report and take a decision. So this is the concept of living wills. It is evolving. So it is going to develop further. Because even today, even as per the amended guidelines called Advanced Medical Directives, AMD. Advanced Medical Directives is what the Supreme Court framed to be followed in 2018 in common causes case, and now modified, watered down, but I would say not very much watered down. It is still a tedious, very cumbersome process, which probably will outlast the lifetime of the person who is actually terminally ill. So probably courts will evolve a better system. Now this is what's called living will. Then we have international wills. India is not a signatory to the Convention of International Wills, which was signed in December 1973. So we are not concerned with international wills as on date. But to give you a brief bird's eye view of what an international will is, the international will, they have a common form by which a person can write a will. It is recognized all over the world. So the question of domicile does not have any play. A person who can write a will here, he must be a dominus here. He must have a domicile here. But in an international will, I can write a will anywhere in the globe to cover properties anywhere in the world. It need not be necessarily in India, not necessarily in Sri Lanka or Pakistan. I can write a will in the United States of America covering my properties in all other places. Then there is a very interesting concept called concurrent wills. I write two different wills. So I was also perplexed. I asked a lot of seniors when I was practicing, what is this concurrent will? I don't believe in this system. Because what we say is the last will and testament. So the will, suppose yesterday I write a will, today I change my decision, write another will, today's will is the last will and testament. So therefore, what is this concurrent? Last month I write a will, next month I write a will for my Bangalore property, last month it is only for my Madras property. Law recognizes. In so far as the Madras property will written last month is the last will and testament. The will I write yesterday for the Bangalore property is the last will and testament insofar as the Bangalore property is concerned. The important factor here is there must be no overlapping. If there is an overlap by chance, then the last will prevail. In fact, section 88 of the Indian Succession Act, here I would refer, is a very, very important section. Unlike any other document like a sale deed or a release deed or a settlement deed, where the earlier clause will prevail. Suppose in a sale deed, I say, I have sold the property to Srinath. Then few pages later, there is something contradictory to that, and I am saying, no, the property is given to Rajesh. So what is the effect of that sale deed? The moment I say property is transferred to Srinath, that stays. Whatever contradiction is there in the later part of the document will not hold water. So the first part of the document will be valid. But in a will, it is reverse. Because the concept is the last decision of mine, the last wish of mine is holding good. So in the earlier part, I am saying that two of my children should take the property. But later on I say only my eldest son should take. It may be a mistake. But if it is in respect of the same property and there is a contradiction, it only the later part will prevail. This is section 88 of the Indian Succession Act. In fact, if you see Succession Act, it itself is an act, evidence act. It lays down how the will should be interpreted, the words used, so many sections, right from section 74, how the will should be interpreted, how the bequest should be interpreted, what if there is a clash, who should be given priority, all these things. It is an evidence act by itself. But invariably, we don't go into much details. We are sticking only to section 63 of the Succession Act and read with section 68 of the Evidence Act. What are the advantages of writing a will? First, you can do it at the convenience of your home. There is no prescribed form or rule to follow. You can, whatever you want, you write down on a piece of paper. No stamp paper is required. Registration is not required. This is a convenience. Most important factor is you can put conditions in a will, which you cannot do in a gift deed or a settlement deed. Conditions can be ignored unless it's an onerous gift. So that is the most, and the other point is future properties, which you can never deal with a property which I don't acquire today. I am going to say in my will, whatever properties will come to me in the future, or at the time of my demise, the property is available to me, that also can be subject matter of a will, which is a very salient feature of a will, which you will not get in any other document. Because you can't anticipate something in a sale deed or a settlement. You have to be specific. It has to be restricted to the schedule described in the document. Whereas in a will, you need not give a schedule, no form, no stamp paper, can be in any language you prefer. The only requirement is 2 witnesses. A minimum of 2 witnesses. And here also, if you see, in fact, sitting in the bench last 1 week, we have been seeing cases where lawyers have mishandled cases. We are very certain that the will is genuine, true and genuine document, but unfortunately, there is no proof. What is the proof required for a will? You will have to adduce. This is where section 68 comes into play. Section 68 says you will have to call at least 1 attesting witness to prove the execution of the will. There are 2 attesting witnesses. Section 63 says how the will should be attested. So the testator must sign in the presence of 2 witnesses. 2 witnesses must sign in the presence of the testator. So these 2 parts are very important. You will have to prove it in execution. You will have to prove it in trial. So you will have not just say I signed the will in the presence of 2 witnesses, it is not sufficient. You will have to say the testator signed in the presence of 2 witnesses, and the 2 witnesses signed in the presence of the testator. And the testator saw them signing as attesting witnesses. Thirdly, most importantly, the attesting witnesses must speak about the mental capacity of the testator. At that point of time, the testator was in a sound and disposing state of mind, memory and understanding. This is the requirement for proving the will. And there may be cases where the attesting witnesses are no more. One attesting witness is alive, one is not found, or both are dead and gone. Evidence Act provides. What if both the attesting witnesses are not found? Section 69 comes to your rescue. Here again, the law is not clearly followed or understood by very many lawyers. It again consists of 2 parts. Please remember, it consists of 2 parts. Number 1, you will have to prove the signature of the testator. So you will have to examine a relative, son, daughter, or even the propounder can say, yes, this is my grandfather, this is my uncle's signature, I am aware of it. Subject of course cross-examination. Second and most important part is where a lot of advocates don't follow. It is that you will have to prove the signature of the attesting witnesses to be in his handwriting. So once there are absence of 2 witnesses, you prove the signature of the testator, you call one person to prove the signature of one of the attesting witnesses. So you examine his wife or son or daughter to come and say, yes, this is my father's signature. That is all you will have to do. You are not concerned about the execution of the will. Makes things very simple. But for a witness, the burden is even more. He has to undergo grilling cross-examination as to what circumstance the will was written, when it was written, what time, who are there. So many questions will be heard. But for following 69, nothing is required. Person only gets into the box and says, this is yes, I am identifying my uncle's signature, he is the testator. Then you call one more witnesses and say, this is my father, my husband, my sister's signature. She is one of the attesting witnesses. That is all the law requires. Act also provides where witnesses turn hostile. There may be cases where will was executed in the presence of 2 witnesses. Property is given to the daughter. The son goes and horse trades, probably is a politician. He wins over the 2 witnesses. Both the witnesses come and turn hostile. They say, no, we don't know. We don't know, we didn't sign in his presence. Still, the Evidence Act gives an option to prove the will. Divorce the attesting witnesses turning hostile under section 71, you can prove by adducing other evidence. You will have to prove probably some other signature that is his. There are other modes to prove the execution of the will. The initial burden is discharged the moment you say that this is what we have done it, execution is proper, we have attested in his presence, his mental capacity to sign, he knew what he was doing. The burden shifts to the person who opposes the will. The person who opposes the will is called a caveator. He should have a caveatable interest. This is fundamental. So, who is a person who has a caveatable interest? A person who will get a share in the property but for the will. He has a caveatable interest. Your neighbor cannot say, I have a caveatable interest. My tenant cannot say, I have a caveatable interest. Suppose a will gives the property to 2 sons and disinherits 5 daughters and the wife. The wife and 5 daughters have caveatable interest because but for the will, they will get a share in the property. Therefore, person who has caveatable interest is a person who will get a right in the property. Even a fraction of right is sufficient. But there are judgments of this court which say even a mortgagee has a caveatable interest, because he has a right to bring the property to sale and get his money realized. So there are judgments which say a creditor, a mortgagor, they also have a caveatable interest. And whatever little fraction of caveatable interest is there, you are entitled to oppose the grant. What do? You file a caveat. It is very similar to the caveat we filed under section 148 capital A of the CPC. But it is filed under the original side rules, which so far the Madras High Court is concerned. You can file caveat, regular caveat in the district court. So district courts also have the power to grant probate and letters of administration. But here we have the High Court, which is the primary court, under section 300. The High Court will have the original jurisdiction to grant probate and letters of administration. So you file a caveat. A lot of you may not know this caveat is valid for 6 months. It is not just 3 months, like 148 caveat. The caveat filed under the Indian Succession Act is valid for 6 months. So what is the procedure? Not mere filing of a caveat is not sufficient. You will have to file an affidavit in support of the caveat within 8 days from the date of filing the caveat. The requirement of the law is within 8 days you file an affidavit of supporting affidavit to state why you are opposing the grant. But that is not, there is not going to be any roving inquiry into the affidavit. You just say, I suspect the truth and genuineness of the will, there is another will, or this is not a signature. Any one single objection would be sufficient. The moment this requirement is satisfied, caveat and an affidavit of objections are filed within 8 days. You can do it together. Best thing is to do it together. Otherwise you may forget, your office clerk may leave it. Better to file the caveat and affidavit of objections in one shot. The moment you file it, if it is in order, you serve the other side, registry accepts it. And one more feature in the original side is, unlike the other caveats, the council can go and fill up the caveat register and assign the number. We don't require the registry to do it. We go to the original site, there is a separate OP caveat register. You write the name of the caveator, name of the petitioner, you give a number to the, you follow the serial number. The earlier one was 147, you give 148. Your caveat number will be 148 of 2013. Notice will go to the petitioner saying that there is an intention to oppose. The moment your caveat is accepted and registered, the OP will be converted as a testamentary original suit, where the petitioner will become the plaintiff, the caveator will become the defendant. There are cases where the array of respondents may be 7 or 8 in the OP. All the other legal heirs who have been disinherited or persons who have given consent, all of them will be cited as respondents in the OP. But only the person who files a caveat will become the defendant. This mistake I have seen in a number of offices where they automatically show all respondents as defendants. Only the person who files the caveat will become a defendant. All the other respondents, either they remain ex parte or having given consent, they are not concerned with the proof for trial of the will because they have chosen not to oppose. This is with regard to, becomes a TOS, you will have to pay separate court fee. Now, court fee, you know, we were paying 3% originally. After the 2017 amendment to the Court Fees Act, it is now treated as court fee. Previously it was being taken as probate duty, 3% of the market value. But today we pay a flat 25%, be it probate, letters of administration or succession certificate, it is only 25,000. But the problem is, if there is a contest, you will have to pay half of the value of the property, half court fee on the value of the property. So suppose you valued the estate at say 1 crore, you will have to pay 3% on 50 lakhs when it becomes a TOS. For the OP it is only 25,000. But when it becomes a TOS, you will have to pay 3% on 50% of the market value. Originally we followed the earlier High Court court fee, which was much lower. For the first 1 lakh it was 4,525. Remaining rest of it will be 1%. But now it is a flat 3% you will have to pay. So once you do that, you will have to prove the will in the presence of the caveator or the defendant. We have already seen how the will should be proved. After proof, what happens? Suppose the defendant raises suspicious circumstances. The initial burden is always on the propoundor to dispel all suspicious circumstances which cloud the due execution of the will. Defendant might say, what is suspicious circumstance is not defined anywhere. We have only, by march of law, we are probably able to say this is a suspicious circumstances, X, Y, Z, we are able to give illustrations. The handwriting of the person is shaky. He was of feeble mind, he was in the hospital when he executed the will. He was aged 94, he did not know what he was doing. There was no way he could have disinherited the daughter. Daughter was living, taking care of the man, old man. All these are suspicious circumstances. But there is a very classic case which I was fortunate to be involved in. Because sometimes it becomes interesting to hear cases which actually, in fact this case went up to Supreme Court. A very famous reported case, Shekhar versus Geeta, 2009, 6 SEC, page 99, if I'm subject to correction. Shekhar versus Geeta, but more focus was on the Hindu Succession Act. Whether the Amendment Act 39 of 2005 was prospective or retrospective was the issue on which the matter went to Supreme Court. But incidentally, the will set up by the brother was disbelieved. It was a case where the man had 4 daughters and 1 son. Son was residing in the ground floor. 1 daughter was residing in the first floor. Another daughter was residing in the outhouse. This old man from Rajasthan, his name was Govind Singh. They migrated to Tamil Nadu about 400 years back. Their ancestors migrated. He was doing a business here. His son was helping him, but he was not very fond of his son. But he used to shuttle between the ground floor, first floor and outhouse. Sometimes he will stay with the daughter, another daughter, son. But he was not very happy with the son. So the daughters filed a suit for partition. The son set up a will. Copy was not given. Till such time the partition suit came for trial. The other side refused to give a copy of the will. And we had to file an objection affidavit. So we said, no, this man he has equal love and affection for all of us. No way he would have disinherited the daughters. At least the 2 daughters who were taking care of him should have been beneficiaries. We don't believe this will, we don't trust this will, is what the objection we took. That man was in the hospital on the day the will was executed. The affidavit of attesting witness said he was at the residence. That affidavit attesting witness went missing, the original side. Then the Xerox copy was marked. A blessing in disguise for us. We found that in the Xerox copy, the TOS number was mentioned. The affidavit should be filed along with the OP. It cannot even have the OP number. But TOS number was mentioned. There was some noting on the last page, the Xerox, 12 rupees, 5 rupees, the date. 1 week prior to the filing of the Xerox copy. So we said, and the advocate who drafted the will came voluntarily to the witness box. She said, I am the family advocate of the testator. She gives a reply. The moment the partition notice was, pre-suit notice was sent, this lady lawyer gives a reply. And the tenor of the reply heightened the suspicion. The reply notice does not even say under instructions. Straight away it says will is genuine, you have no right, truth will triumph. 4 lines. Truth will triumph. Not even under instructions. So I didn't expect this advocate to come and give evidence. She got into the box voluntarily. First question I asked her, Madam, how many cases you have done for the testator? She was blank. Not even a single case. The man had no case yet in Madras High Court or City Civil Court. What is the mother tongue of the testator? No answer. What are the names of his daughters? She does not know. Everything negative answer. Everything was in our favor. Then I asked her why the will was in Tamil. The man does not know Tamil. He can speak good Tamil, but because he was in Rajasthan, his mother tongue was Marwadi. Therefore, he didn't know to read and write Tamil. Very surprisingly, there was an affidavit confirming the will. That was, the affidavit was in English. Stamp paper was purchased in Erode, somewhere. That affidavit in English says, today I have executed a will. Will is an ordinary paper, stamp paper provided by the advocate. She claims to be the notary, and we were able to demolish the entire evidence, and we succeeded before the single judge. And single judge on 39, he said, the illegitimate son was there. So he claims partition, therefore the dwelling house will not arise. But our argument was already daughters are there inside the property. Therefore, you should not apply section 23. Because under section 23, before it was omitted by the 39 of 25 Act, a female member cannot ask for partition of a dwelling house wholly occupied by male members. So we said already it is not wholly occupied. Sisters are there. And the moment the brother sets up a will, that means he wants a partition. Partition, as we all know, can be inequitable. Partition need not be equitable. So what our argument was, the moment the brother set up a will, that amounts to a partition. But the case was not gone into, but illegitimate son made a filed a written statement supporting partition. Therefore, learned single judge said yes. The appeal, OS appeal, before Justice P.K. Mishra, he wanted to go into the effect of Amendment Act 39 of 2005, whether prospective or retrospective. So on the will, we succeeded, but whether we are entitled to file a suit for partition of a family dwelling house. Then the learned judge said, appeal is only a continuation of suit, therefore we can give retrospective effect. That was taken to the Supreme Court. And Supreme Court said, oh no, it is only a prospective litigation, prospective enactment, you can't apply it retrospectively. However, already the son who set up a will has lost. There is no purpose in sending back the parties to file another suit. Therefore, they said they confirmed the preliminary decree. This is how it went. So it is very interesting when you go for trial of will cases. It is very, very interesting. You will have a lot of material to cross-examine. And my small tip, I will say, attesting witnesses, you cross-examine on the same day. Don't give them time. They won't expect. They only 100 here. 10,000 lawyers won't know the secret. Don't give them an opportunity to go home and be tutored. If you are going to cross-examine an attesting witness, do it on the same day. If he finds the proof of it, you are bound to succeed. He will not speak the truth. He cannot justify due execution. In fact, I examined 6 witnesses on a single day, back to back, asking the other witnesses to stay outside, an additional master, one. Back to back, 6 witnesses, 3 attesting witnesses in the will, and 3 more witnesses in support of execution. Back to back, 6 witnesses, 5 will stay outside, 1 will come in. Moment his cross-examination over, another person, 6 people gave 6 different versions. If you give them time, definitely they will be tutored, they will be very smart when they come for cross-examination. It's a small tip which I learnt doing many TOS matters. So this is how you attack a will. Suspicious circumstance, coming to that, initial burden is always on the propounder. But again here, a lot of people don't know what point of time suspicious circumstance is relevant. The suspicious circumstance must surround the execution of the will, not something which happened 20 years back. It should be surrounding the execution of the will. If there are serious suspicious circumstances, then one side say this will has been duly executed and burden shifts to the defendant. If the plea of forgery or undue influence is taken, it is burden on the defendant to prove plea of undue influence, forgery, coercion, whatever. But initial burden is always on the propoundant. For example, like a suit for specific performance, the burden is always on the plaintiff to show ready and willing. Whether defendant comes to court, remains ex parte, or does not even admit the agreement, still the burden is on the plaintiff to show that he is ready and willing. Similarly, the burden is always on the propounder. You cannot say that, no, I need not prove the will. Yesterday we gave a judgment sitting in the division bench where we overturned about 3 or 4 judgments of the Madras High Court for referring to a Supreme Court judgment. Very interesting. Where the plaintiff seeks for partition. Plaintiff, even in the plaint, admits to will number 1. But her case is, it was superseded by will number 2. Will number 2 is bogus. Therefore, I am entitled to 50% share in the property, is the case of the plaintiff. The defendant says, no, will 1 is genuine. Will 2, I am not concerned. You give me as per will 1. Trial court goes into the veracity of second will and says this is a concocted will, not a genuine will. He will believe the first will. we leave the first will, give the property to the son, the first defendant's son. Matter came up on appeal. An argument was advanced before us saying that will has not been proved. The trial court gravely erred in granting a decree dismissing the partition suit because no attesting witness has been examined. Will has not been proved. It is mandatory to prove a will under section 68, at least section 63C was the argument, relying upon a judgment of the Honorable Supreme Court, which has been followed by at least 3 or 4 judges of learned single judges of our court. Then we drew a distinction between what is not specifically denied, what is specifically denied, what is admitted. In the Evidence Act, what is admitted need not be proved. Right from section 17 and then 56 to 58, what is admitted need not be proved. It is not a fact and issue. We follow the adversarial jurisprudence in India, like the British system. Parties are at issue at loggerheads on question A, question B, question C. Your trial is limited to those issues. Here the plaintiff herself in the plaint admits that there is a will. She does not dispute. So there is no occasion for the defendant to prove the will. No occasion for the trial court to frame an issue that the will is genuine or not. And when there is a categorical admission, so we said on facts, the issue before the Supreme Court was the will was under dispute. Therefore the Supreme Court said, even if the other side had not specifically denied, still the burden is on the propounder to prove the will. He has not examined witnesses, therefore we are holding that the will remains unproved. But in our case, the plaintiff herself admits. So we have distinguished between admitted, what is the effect of an admission under the Evidence Act, what is specifically denied, what is not specifically denied. This judgment given yesterday. This is again very interesting. Section 70 also you may remember, keep in mind. We had to apply section 70 also to this case. Section 70 is where, even though the document requires to be attested or proved in terms of section 68, where the executant himself admits in any other proceeding about the genuineness of the document, then it is assumed to be proved. You can hold it against him to be proved. In this case, what happened is the testator himself during his lifetime filed a suit for injunction. He files the original will in the trial court, in the injunction suit. So we said section 70 also will additionally apply. Leave alone admission. Section 70 also stares in the face of the plaintiff. Because the father himself has come to court and said, I have written a will. No better person to say I have written a will. He does not refer, by the time he had not written the second will, which has been disbelieved by the court. But the first will, original, has been filed in the injunction suit. Therefore, we have now followed some of the judgments pre-Supreme Court judgment in 2017, which are now set at naught by the Supreme Court, interpreting that when it is admitted, you still have to prove. We will have to see whether this judgment is going to stand in Supreme Court. Anyhow, we made a conscious judicial discretion available to us. Advantages of writing a will, we'll come back to that. There's no form, no stamp paper, very inexpensive, but there are disadvantages also. Suppose the will need not be registered, it's not a compulsory registrable document. You don't have a copy, the will is lost. The very purport of the will goes. The person who is benefited is not able to lay his hands on the will, original is not available. Therefore, the very object of writing a will is gone. So it's preferable to register. But courts have time and again said, just because a will is registered, there is no special status or sanctity given to it. To me, if you ask me, only advantage is you will get a certificate copy. Nothing else. By the march of law, only advantage of registering a will is you can get a certificate copy. There is also an interlinking of the Registration Act here. Section 40 and 41, the testator or after the demise of the testator can go to the registrar, and any registrar, not the jurisdictional registrar. I may be in Tinagar, I can go to Ashok Nagar and say, I want to safeguard my will, register my will. Section 40 and 41, the testator during his lifetime or even after his death. So I am afraid my brother is going to destroy the will, property is given to me. I can rush to the sub-registrar, invoke section 40 and 41, the Registration Act and chapter 8 and say that please register, I want to safeguard this will. That option is open even after the demise of the testator. The other option is the testator himself goes, or the agent of the testator. Sections 46 to 49 of the Registration Act under Chapter 9, where the testator can lodge Book 5. It will be registered in Book 5 of the Registration Act. So it is sealed cover, it will be registered. And it will be given only after the demise of the testator. Unless the testator himself goes and says, no, I have cancelled the will, please return it. Otherwise, the legatees, on showing proof that he is a son or daughter, legal asset surrogate or other something, you will get back the original will and deposit in court. Then concurrent jurisdiction, where to file? When is probate required? Now coming to difference between probate, letters administration and succession certificate. If probate, now it's only to the named executor. Will must name an executor. Only then probate. Now, general colloquial we say probate. Will is not probate, not so. The will must name X, Y or Z to be the executor of the will. Again, executor, a lot of people confuse. Testator is not the executor. Testator is the executant. Executor is the person nominated or appointed by the testator in the will. There must be an express or implied appointment of the executor under the will. Then that person, he need not be a legatee, he need not be a beneficiary, he can be a beneficiary. There is no hard and fast rule. Suppose there is only one son. I don't want to trust X, Y, Z. I will make my son as the beneficiary, also the executor, sole executor. There is no bar. So sole executor, or you can have two executors, multiple executors, either or, joint. It's up to the testator. It's always the will of the testator which is going to prevail. Once the testator appoints somebody, trusts somebody, then it is only a case of probate. Suppose he writes a will, but there is no nomination of an executor, then it is called letters of administration with will. Letters of administration can be applied only by a legatee under the will. A beneficiary alone can make an application for letters of administration. A person who is not given property, or a neighbor, or an uncle or aunt cannot move the court and say, give me letters of administration. It is only the legatee or beneficiary under the will who can approach the court and say, give me letters of administration. There is also a case where letters of administration without will. This is a speciality of the Succession Act. You can also get a letters of administration where there is no will. We have seen a case where there is will, probate, executor appointed, will, no executor, letters of administration with will. Where there is no will, properties comprising of immovable properties and or movable properties, your remedy is move the High Court or the District Court for letters of administration without will. The burden will be definitely slightly higher on the petitioner in cases of letters of administration. The purpose being, you go to court and say, I am so and so, I want the property, I am a beneficiary under the will, under the estate, you give me the property. Therefore, there is a distinction between probate and letters of administration. Letters of administration, person wants to get an order, whereas in the probate case of probate, testator himself nominates XYZ. He trusts his son or friend or chartered accountant or lawyer and nominates him as executor. That is why in cases of probate, the court does not order publication. There is no general publication calling for objections in a case of probate. You will only have to put the legatees on notice. That is, the heirs who will be entitled to the property but for the will. Those persons alone will be arrayed as respondents. The executor will be the petitioner. No paper publication. But in the case of letters of administration, you will have to mandatorily give advertisements in two papers, one English and one Tamil daily, with a gap of 10 days, calling for objections. So this is for letters of administration. Third category is succession certificate. Succession certificate, no will, no immovable property, only movable properties. Then you apply for a succession certificate. Sections 370 to 390, last part in Succession Act deals with succession certificates. This is the distinction between probate, letters of administration and succession certificate. The advantage of having an executor we have already seen. So you know that a person can go around this job. You nominate somebody, he takes care, he is responsible for the estate. He will have to file an inventory account. He does not go scot-free. An administrator or an executor is still supervised by the court even after the probate or grant of letters of administration. He is answerable to file inventory and accounts. He must come back to court and say, yes, I have fulfilled X, Y, Z, A, B, C, whatever the testator wanted. He may have said, give it to charity. So all that he must file inventory and accounts, substantiate it and file within 6 months, an inventory and accounts within 1 year. If he does that, his job is complete. Here also an interesting case came up where the letters of administration was granted to the beneficiary. Does he get the property as an administrator or as a beneficiary? If you see the original probate granted, there will be a condition on the reverse saying that administrator cannot deal with the property without the prior permission of the court. So there was a case where the administrator completed with all the formalities, he is the beneficiary, he sells the property. Then objection is taken, saying that you have sold it in violation of the condition granted. There's an express condition that you should get the prior permission of the court, you have not done it, therefore revoke. Then we argued saying that the difference between an act of administration and enjoying the property as an ultimate beneficiary. I drew a distinction and we succeeded up to Supreme Court, where the Supreme Court upheld the single judge's finding that the act as an administrator gets over the moment inventory and accounts is filed. I am discharged from my role as an administrator. Thereafter, I may be the beneficiary, X may be beneficiary, Y may be beneficiary. Moment administration is over, the legatees as beneficiaries, they are entitled to deal with the property for which no permission is required. Only if I sell the property as an administrator, I will have to get the permission of the court. This is one. What is the requirement for probate? We all know we have 3 chartered high courts, Madras, Bombay and Calcutta. So there are again 2 conditions. One is the property is situated within the territorial limits of these 3 high courts, Madras, Bombay and Calcutta. Section 57 says you have to probate. Second requirement is will is written outside. Suppose Bangalore the will is written, but there is a property concerning property in Madras or Bombay or Calcutta. Even then, will has to be probated or grant of letters of administration will have to be obtained, depending on executor being named or not. So 57 deals with, section 57 deals with both these. Read with 2 and 3, you will have to file an application. So 2 requirements, 3 high courts, property either within the territorial limits of these 3 high courts or will written outside, property here, or will written here, you will have to probate. No, even a will is outside, property is outside, will is written in Madras, you will have to probate. These are the, and where do you go? There is a parallel jurisdiction, concurrent jurisdiction is given to district courts as well as the high court. But insofar as 3 chartered high courts, it is always before the high court. You cannot go to the district court. But in all other states, the district courts have concurrent jurisdiction along with the high court. Unless the state government concerned makes a notification saying that no, only the high court is our jurisdiction. And like it will become like Madras, Bombay and Calcutta. Otherwise, you can file it in the district court or in the high court. You have concurrent jurisdiction under 300 capital A. This is with regard to filing. Then what happens after the probate is granted? The will, you must all remember, comes into effect the moment the person dies. So it vests in the estate or the legatee or the executor the moment the person dies. It does not depend on the fact of getting probate, applying for probate, no. The moment the person dies, the will takes effect. Until then, it is only an ordinary piece of paper. It is a mere declaration of somebody's wish. It acquires the legal character of a will the moment the person dies. It sits on the shoulders of the executor or the beneficiaries under the will. But in the case of the executor, the Succession Act gives him extra powers. Again, why? Testator himself nominated. Therefore, he can deal with the property as he thinks fit. He can collect rents, he can evict tenants. He does not require the permission of the court. As long as he is empowered under the will takes effect the moment the person dies. The executor has a free hand. But in the case of letters of administration, the administrator must approach court for anything and everything he wants. He cannot take unilateral decisions. He has to make an application, seek the permission of the high court or the district court to act or preserve property, protect a property, vacate a tenant. Administrator cannot take up the mantle upon himself unilaterally. So this is with regard to probate and letters of administration. Succession certificate, will not do nothing to do with wills. So that is succession certificate. Then coming to, so when probate is required, I told you, probate is required if either the will is written here or properties within the jurisdiction of these three courts. You have already seen the special characteristics of will. Then who can write a will? Any person who is of a sound mind, more than 18 years, is entitled to write a will. Even an illiterate, blind, dumb, deaf person can write a will. Even a lunatic can write a will, provided the will is written when during his period of sanity. He can write a will. A specific section 59 is available under Succession Act. Insofar as religion is concerned, Hindus, Buddhists, Sikhs, Jains, Christians, there is no restriction, they can write a will. When it comes to Muslims, they cannot write a will exceeding 1/3 of their estate. They can settle the property, they can give a hiba, the entire property, execute a settlement deed, register a settlement deed, but when it comes to will, property bequeathed under a will cannot exceed 1/3 of the total estate. We have seen the privileged wills, unprivileged wills, and coming to another interesting question, whether the beneficiary can be an attesting witness. We have seen already, executor can be a beneficiary. There is no harm, no problem. But can an attesting witness be a beneficiary? The Act has only one section, section 67, which says, will does not become invalid, but the bequest made to that attesting witness and his spouse will become invalid. But this has to be read with Schedule 3 of the Indian Succession Act. To section 57, there is a schedule which says some of these sections will apply only to Christians. A list of very many sections of the Indian Succession Act are set out in Schedule 3, read with section 57. There is Schedule 3 to section 57. This 67 limits the application of the section only to Indian Christians. So therefore, only when it comes to Indian Christian wills, the beneficiary should not be an attesting witness. He can be, but he cannot expect to take the bequest given to him under the will. Even his spouse is disentitled. His or her spouse is disentitled. This embargo is not available to Hindus, Buddhists, Sikhs, Muslims, Muslims. But it is always safe. See, it is again another suspicious circumstance. Active participation of the beneficiary. He is an attesting witness. Better to avoid. But there is no legal impediment for a beneficiary to be an attesting witness. Then again, this how to write a will.
Joint wills.
Joint will. Chota. Ye later on. No. We have seen requirements for execution of a valid will. How to draft a will. Make it very simple. No flowery language. You need not show your linguistic skills in a will. Because tomorrow the person who writes the will is not going to be alive. His intention, laudable intentions, solemn wishes are going to be tested. Therefore, make it as simple as possible. Don't complicate flowery language. Dictionary make it as simple. So the reader should know what the man intended. So you take full instructions and find out what is the true intention, why he wants. There is no necessity that you should give reasons why you are giving it to somebody, but it is always advisable. Because today every will is contested. The property prices have gone up so much that even genuine wills are lost, are disbelieved by courts. With passage of time, the effect, the very purpose of writing a will is defeated. Therefore, you encompass everything which is you contemplate as a defense when you draft a will. Why he is not giving it to the daughter, why he is not giving it to the son, etc., etc. Here I am reminded of a joke. The person was always at loggerheads with his son. So his will is read out after he dies. To my loving wife I give the property at Uti, and I give my farm to my daughter, and my son who always fights and antagonizes me, hi. I'm sure you are not expecting me to mention your name in my will, but I didn't want to leave you out. So it is always better to say why you are leaving out somebody. That is because will is going to be tested tomorrow. Sitting in the armchair of the testator. This principle has been evolved by the Supreme Court in very many cases. You sit in the armchair of the testator and think, would he have done this in the circumstances, like take case of Shekhar and Geeta. Two daughters in the same house, taking care of the father. Will such a father say, no, I am giving it only to my son, I am disinheriting all my 4 daughters? So sit in the armchair of the testators and see the circumstances under which the will was made. Would it be probable for a person to make such bequest? The court of conscience. You don't approach the will with suspicion. So court of ultimately, because we are dealing with a solemn last wish of a dead person. So you must, as far as possible, try to give benefit of doubt in favor of the will. Unless the evidence is so shabby or there are so very many suspicious circumstances, it could not have been probable to have executed such a will. These are, language of the will is very important. Make it as simple as possible, no complication. Give reasons why you are preferring somebody, why you are not preferring somebody. Suppose there are changes or alterations. If there are material alterations, preferably take the initials at the relevant places or make a fresh draft and get it signed. So this document is going to be in the court for at least 25-30 years. It will be in the registry for 150 years. So therefore you have to be very careful. If there are material circumstances, better. And here comes the concept of a codicil. A codicil is an addendum to a will where you make alterations, additions to the original will. It is not necessary that a person has to execute a codicil. I can straight away execute a fresh will. It is only an option. Codicil is only an option given where, say, the testator I named had died. So I just write a codicil and say I had named X as the testator, executor. Executor died last month. Therefore, Y will be the executor. You can write a codicil. Codicil is also required to be attested in the same manner as the will. Not only attested, executed, attested and proved in the same manner as you. Not necessary that the codicil should overstep the will, can also overstep the will. So it will be treated as a separate will. Ultimately the court will decide. If you are going to prove the will and codicil, the codicil is the last will and testament because it is executed subsequently. So if there is any overlap, the codicil will prevail. So you can advise the client whether a codicil is required. There is only a small description, a misdescription which you can correct by a codicil. But given that it requires the same formalities, it is better to write a fresh will instead of avoiding a codicil. Because anyhow, later will is going to prevail. You also preferably get instructions in writing, retain the instructions and draft. I find of late number of advocates are called to give evidence in testamentary matters. So please retain the draft or the instructions you receive from the testator. Full instructions of family details, everything. So if this lady in Shekhar Gita had got instructions, she would have known details of the sisters, mother tongue, she didn't know anything. So basically you equip yourself. The client may come to us, may not come to us, but at least you equip yourself and avoid putting drafted by in wills. You are inviting trouble. But sometimes very close family members, we cannot say no. But in those cases especially, be careful, retain the instructions, retain the draft you have prepared so that there is correlation. And suppose the testator is illiterate, then make a specific jurat saying that it was read over in the mother tongue, so Tamil, Telugu or whatever, or write the will in the preferred language of the testator. That is the best part you can do. There is no other translation the problem. You'll have to wait for 3 months to get the will translated in the High Court. So at least the jurat portion can be taken care of. And left thumb impressions. There are judgments, one Andhra Pradesh judgment where it upheld a right thumb impression made in the will. There is no hard and fast rule that only left thumb impression should be obtained, but safer. But do as Romans do. Don't change and your wills on stamp paper, wills with 6 witnesses. That by itself will create a lot of suspicion. The will written in the hospital gives full description of the property. Survey number, boundaries. The opening words of the will says, fear of death came to me only after I admitted yesterday. So you don't expect the man to go with a suitcase with all his documents to the hospital. So all these small things you can be conscious of while drafting a will. Then comes limitation. See, previously there was no limitation for filing an application for probate or letters of administration because you are only ascertaining a right which is already vested in you. So you cannot say that the right is shut out by law of limitation. This was the consistent view of the Madras High Court, Division Bench Justice M. Srinivasan. They said no limitation, but they introduced a specific rule in the original side rule saying that if the delay is beyond 3 years, you explain the delay. Most of us don't do. It will have a fatal backlash when matters sought for will is sought to be revoked. So you will be very careful. There must be cogent reasons why the petition was not filed within 3 years. That is sufficient. That is the law. But 2008, Supreme Court said Article 137 of the Limitation Act will apply to probate and letters administration. If, whether it, when does the cause of action start? Date of death, date of will, date of death, date of knowledge, so many factors. You don't know. But Supreme Court just said Article 137 will apply. They gave contradictory illustrations in the very same judgment. So there was a lot of confusion, but safely everybody was adopting. Till 2005, and Division Bench of our High Court in Santappan was the Andhra Bank. Justice Sanjay Kishan Kaul and Justice Pushpa Satyanarayana, they made a clear distinction and said position with regard to original side is totally different. So in a chartered High Court, we are governed by the OS rules. We are not governed by the general law. Therefore, when there is a specific rule saying that there is no limitation, you only have to explain. It is enough if you explain the delay, you are not bound by Article 137. That was again followed by just C.T. Silvam and said it is only date of knowledge. There may be will, in most cases, a secret document. It may come to light after 10 years, we don't know. Person would have kept it in a bureau, kept it in the locker. There is occasion to know the existence of the will itself, you may not know within 3 years. To say that you will have to make an application from within 3 years from the date of demise is too much for the asking in case of wills. Therefore, the division bench set right the position and said in the High Court, as far as the Madras High Court is concerned, we are governed only by the judgment is 2016 1 CTC 257 Santappan versus Andhra Bank 2000 sorry it is Vatsala versus K.S. Mohan 2016 volume 1 CTC 257. Yeah, academic interest, I will tell you, we have two forms of probate. One is called the solemn form and one is called the common form. So the British system, they were having the common form. In the absence of the interested parties, probate will be granted by British courts. But this system is unknown to India. Actually now it is compulsory that you will have to make interested parties as respondents, you will have to prove the will in their presence. So we adopt only the solemn form. So therefore there is no difficulty. Academic interest, there are two types of probate, common form and solemn form. Then limitation we have seen. The Supreme Court judgment 2008 8 SCC 463 saying that Article 137 will apply. Kunwarjit Singh versus Kirandeep Kaur 2008 volume 8 SCC 463. The next question is who marks the will? Again, an interesting debate. Who marks the will in the court? Is it the propounder or is it the attesting witness? In the district courts, if you see invariably, the attesting witness alone gets into the box. He marks the will because he is a witness to the document. He is the best person to say this will was executed in my presence. So even before the propounder, the witness will be examined, will is marked. But in the High Court, we have been following a procedure where the petitioner propounder, because its will is already filed into the registry by the propounder. Therefore, when he gets into the box, he marks the will. An objection was taken in a case where I appeared, saying that no, you cannot mark the will through the propounder, only the attesting witness, because the attesting witnesses were already on the side of the defendants. So the other side was very confident. He said, no, you cannot mark. He thought he will shut me out in the beginning itself. You cannot mark the will. Original has to be marked. He knows the attesting witness will not come. He has bought them over, turned them over. He is the employees of the deceased. So then we fought and we went back from Master Court, went back to the learned judge. The learned judge agreed with me and said it can be marked, no hard and fast rule. The one Bombay judgment, Justice G.S. Patel had said it has to be marked only through the attesting witness. But our learned senior did not agree with that view, and he said the reason is, I pointed out two things. One, it is already filed by the propounder himself in the court. It is not as if it is summoned from the attesting witness. Second most important reason is, When does the will take effect? On the demise of the testator. Attesting witness will not know when testator is alive or not. Only the propounder comes to court and says, this person is no more, I file his death certificate, will has come into effect. Therefore, you cannot expect attesting witness to come first and say, mark the will. Will takes effect only after the demise. First I have to prove demise. That view was accepted, division bench, up to Supreme Court we succeeded. So now it is an option, you can either mark it through the propounder or through the attesting. That judgment was reported in 2016, 4 Law Weekly 646. Karthik Mayappan was a Sudha Devi. Equivalent is 2016, 6 MLJ 371. In section 90, the Evidence Act, we all know, ancient documents, more than 30 years old. Does it require proof? An interesting debate, law is not yet settled. There are conflicting judgments, some saying 30 it will apply to wills also, some judgments saying no, it will not apply to wills. So Supreme Court is yet to clarify. In fact, if you see the 3 judgments, Supreme Court in Barpur Singh, following Ramesh versus Veeraje Urs. First one, Barpur is 2009, 3 SEC 687. And Ramesh versus Veeraje Urs was reported in 2013, 7 SEC 490. Where the Supreme Court said, you will have to prove. Just because the will is more than 40 years or 30 years old, proof is not dispensed with. You still have to prove the will in terms of section 68 and 63. But Justice G.R. Swaminathan noticed a judgment of the Supreme Court in 1968, Subbaraju versus Subbaraju, AR 1968, Supreme Court 947, where the larger bench held that section 90 would apply to wills also. This larger bench was not noticed either by Barpur or by Ramesh. Therefore, Supreme Court has to necessarily wake up to this anomaly and set it right. But as of now, the later judgments say you should prove, even though it is an ancient document. Then comes revocation of grant. I get a probate. Is it do all end all? Because probate is a judgment in rem. It binds not only the parties, the entire world. It is not a judgment in personam like, say, a promissory note suit or a check bounce case where it is binding only to the parties to the list. A judgment in rem binds the entire world. So therefore, an option has been consciously given under section 263 for revocation of a grant. Some illustrations are given. 5 illustrations are given in section 263 of the Succession Act. Order 25, Rule 62 also deals with revocation of the original state rules. Revocation is possible only for a just cause. In just cause, 5 illustrations are given. What are instances of just cause? Number 1, proceedings to obtain the grant were defective in substance. Suppose you don't make somebody who is interested in the property as a party respondent, it is defective. You have not put somebody on notice who would have thrown more light on the truth and genuineness of the will. It is defective in substance. Grant was obtained fraudulently or by making a false assertion, concealing from court something material to the case. Suppose you knew there was another will which had superseded, still you go to court and say this is the last will. It's a fraudulent statement. Therefore, that is the just cause. Grant was obtained by means of untrue allegation of fact, essential in law to justify the grant, though such allegation was made in ignorance or inadvertently. So as long as an untrue allegation is found, that is a ground for revocation. You may have made it genuinely, not knowing that it was untrue, but still if the court notices an untrue allegation based on which probate letters of decision granted, it's a just cause entitling the court to recall the grant. Grant has become useless and inoperative through circumstances. Classic cases, there is a second will. So earlier will, grant goes, because the later will comes to the surface proved, therefore it can be revoked. Then person to whom the grant has willfully, without reasonable cause, omitted to exhibit an inventory or account. I told you we will have to file an inventory account 6 months and 1 year. That also is a ground for revocation. But courts have not been very serious with regard to clause C. Because reasonable cause you can always say, I was not able to complete the administration. so many bequests made, the charities had to go run around with charities to give the money, distribute the money, sale of property. Therefore, as long as you are able to show that there was a reasonable cause for delay, the courts have been very liberal with regard to clause E alone. But all the other 4, A to D, a just cause is made out, grant will be revoked. Supreme Court and High Court has also said these instances are not the only instances. Just cause can be other instances also, not only limited to A to D or A to E. These are only illustrative, not exhaustive. This is what the Supreme Court as well as the High Court. So in a particular case, what you plead may be a just cause. Therefore, you prove that there is something which is not well with the way grant has been taken by the party from the court. Court will revoke the grant. So what happens? What is the effect of a revocation? Suppose the revocation of grant of probate is made, is ordered. Sister or a daughter is not made a party, or if she give false address given without serving notice. She comes to court, proves that no, I was very much residing in KK Nagar. My brother knows my address. He is wantonly given a false address. I have not received notice. That is the ground for revocation. So once the grant is revoked, the petitioner or the propounder who obtained the grant has to surrender the grant to the High Court. There will be a notice sent to him from the registry asking him to surrender the grant. The original probate will be returned back to the court. Then he has to prove the will in the presence of the person who sought for revocation. So it will go back to TOS. He may have got it as an OP. It will be converted as a TOS. This sister will be entitled to file a written statement, object to the grant. This act of not showing her itself will become a suspicious circumstance. So therefore, that is a case where revocation will be granted. Procedure will be prove the will afresh. When is probate required, we have seen. And again, an interesting, still unanswered question, grey area is, we have seen documents in the city of Madras where title comes by way of a will. Nowadays, some registrars refuse to even receive, saying that no, you must get probate. But I have seen documents, even in 70s, 80s, even today, some registrars agree, there will be a reference, clear reference to the last will and testament of so and so, giving the property to the vendor. Vendor has been in possession and enjoyment for 20 years, under the will, after the will, subsequent after the death of the testator, mutated records in his name. What is the effect of not probating the will? It is a very grey area. I have discussed with this many judges, but nobody seems to have a very clear answer. Definitely a ticklish issue. The section 213, if you see, creates the only bar for probating, not probating a will. What is section 213? You may kindly see section 213. I will read it for your convenience. Section 213. All this is food for thought. You can go home and think. Right as executor or legatee when established. No right as executor or legatee can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of the will under which the right is claimed, or has granted letters of administration with the will, or with a copy of an authenticated copy of the will annexed. This has been now made non-applicable to Christians under Act 26 of 2002. Already Muslims are exempted. This again is a raging issue. Why only Hindus? Today only Hindus, Buddhists, Sikhs, Jains have to probate. 213 applies only to them. Muslims are exempted, Christians are exempted. In fact, the Law Commission has recommended that 213 can be done away with already, together. What are the ill effects? I will come back to it. But the purpose of 213 is only to file a will before a competent court to be received as evidence. It does not say the legatee or beneficiary under a will should not sell the property based on the will. There is the requirement. Problem will come is, suppose tomorrow I purchase the property from Srinath. Srinath got the property from his grandfather under will. There is no probate. Property is very much in Madras, jurisdiction of Madras High Court. I take a risk. I buy the property. As long as there is no problem, there is no problem. But tomorrow, somebody, Srinath's brother, comes and says, no, the will is forged. I also have 50% right in the property. Then the problem will come for me. I cannot file this will before the court of law without the probate or letters administration. As long as there is no problem, there is not an issue, in my opinion, to deal with the property. Beneficiaries are definitely entitled to deal with the property on basis of an unprobated will. Problem will arise only where the requirement is to receive it as evidence in a competent court of civil jurisdiction. If that requirement does not arise at all, you are lucky. But suppose for some reason you fight with a neighbor, in your construction you are redeveloping the property, you will have to prove your title. What is the extent of your property? Your title will flow back to the will. You cannot mark the will. Therefore, again, it is abundant caution, safer. In my opinion, it is not required to probate for dealing with the property, but it is always better, safer. But we do not know when this problem will arise. Problem will arise after 30 years, 40 years, may not arise. But suppose let us a case where problem arises after 30 years. Your handicap will be witnesses may not be alive. How will you prove the will? That problem is there. Therefore, always better to, if it requires probate, please probate the will. Section, that is section 213. Now, come back to it.
Ill effects.
Ill effects of. Ill effects is the problem. I have answered. So I have already discussed. Scribe is not an attesting witness. Scribe of a document is not ordinarily an attesting witness. But on a given fact or circumstance, if he is able to show that he had animus, he acted as the attesting witness, so his evidence will have value. Ordinarily, a scribe who signs the document prepared by, drafted by, is not an attesting witness. Similarly, a person who signs at the registrar's office is not an attesting witness. He is only an identifying witness. See, I may write the will at home today. Today is 10th of March. I keep it at home. I auspicious time, astrologer says signed at 9 o'clock in the night. Registrar office will not be open for me. I do it at home. I call my two good friends, execute the will. Monday, I take it to sub-registrar's office, register it. These two witnesses who attested the will need not come there. I can have somebody X, Y, Z, totally different witnesses to identify the registration. What they do is, they only identify the testator before the registrar. They are not witnesses who can speak about due execution. So there is a difference between identifying witness and attesting witness. Not necessarily that they can be the same, not necessarily they can be different also. So identifying witness is not an attesting witness. Number of cases they bring the identifying witness when their witnesses are not found. It is not enough. It is not sufficient proof. You will have to follow 69. You will have to examine a legal heir or a legatee or somebody who is acquainted with the signature of one of the witnesses. In one case we summoned the chartered accountant who was conversant with the signature of the attesting witness. Because he was a chartered accountant for both testator as well as the attesting witness. So they were from the same community. So therefore we were able to prove the signature of both in one shot. Chartered accountant spoke for signature of testator as well as one of the attesting witnesses. Will was yet to be proved. Another very important factor you must remember is choice of attesting witness. The evidence of an attesting witness makes or breaks a will. He is the person who is going to withstand cross-examination and testify as to the truth and genuineness of the will. If he is a person who is going to be bought over by the other side, then it is going to be stupidity to make such a person as an. So the testator must choose, you must advise. But client comes to you, advise him to choose young person, number one. They all normally prefer their contemporaries. The object, then he will die before the testator. That is not the object of the attesting witness. Should survive the death of the testator and be in a position to speak about due execution. So he has 80 years. By the time will is contested, he will be 94, 95. He won't even remember whether he executed the will. He is not going to help proof of his will. Therefore, advise the client to choose young attesting witnesses, preferably known to the testator. He may be your son's friend, neighbor, some distant relative. So avoid somebody who is acquainted with the beneficiary. Otherwise, they are going to say active participation. He only created the will. Well, I am not good. Person who wrote the will is not alive. So all suspicious circumstances will be thrown at the propounder. Genuine wills will be suspected. So have young witnesses. Credibility of witnesses is very important. They must stand with you, whatever happens. They need not know what you have written in the will, but they should say that all they have to say is, yes, this man Balaji wrote the will in my presence. He was hale and healthy, sound and disposing state of mind and memory. Some incidents you will remember if you are young. Something would have happened, some phone call, some alarm in the office. You will relate to it immediately. All this will help as when the witness is young. He can speak about due execution. Only thing, trust the testator places in the attesting witness. Very important. And don't go overboard. Have 6 witnesses, 7 witnesses, not necessary. Doing something which is not required itself creates a suspicion. Having it on 10,000 rupees stamp paper. Will hardly half sheet of paper is enough for a will. Only requirement is 2 witnesses. No form, no particular way in which you write. It can be Hindi, half Tamil, anything is possible. Therefore, all these small tips you keep in mind, I think you won't have a problem. Because I know of many lawyers who will go any extent to succeed. They will even tell the truth.